Stare Decesis, which is just a fancy way of saying precedents. Follow previous court decisions. All right. Let's go back to sources of law. I just want to make sure I covered a few other things that I haven't covered yet. So we talked about this idea of our poker game and levels of authority. Highest level being, of course, the U.S. Constitution, and we work our way down. And I have those basic 4 primary sources of law in green. But I don't have judge-made law, that is common law, or court decisions. I don't have that one highlighted, nor do I have executive orders highlighted right here. And the reason why, in terms of our poker game, is a court decision is really like a wild card in a way. And what I mean by that is a court decision is interpreting another source of law. So the interpretation or the authority level of the court decision will depend upon the level of law that is being interpreted. So here's what I mean. If the United States Supreme Court is interpreting the United States Constitution, that decision has the effect of essentially becoming part of the U.S. Constitution itself. And so that U.S. Supreme Court, which is our highest court, interpreting the highest level law we have, has the same authority as the Constitution itself, if that makes sense. Because again, what's the court doing? They're not legislating, they're annotating, if you will, or they're adding depth or detail to the Constitution when they interpret it. So if the U.S. Supreme Court is interpreting the Oregon Constitution, not the U.S., but the Oregon Constitution, that is going to have less authority outside the state of Oregon. In Oregon, it will be binding throughout Oregon. But in other states, it may not be because they're interpreting state law, not federal law. So it gets a little bit complicated. So if the U.S. Supreme Court is interpreting an administrative rule, that has the same authority as the administrative rule itself. But it's not going to overrule a constitutional issue. Does that make sense? So the authority, when I talk about my poker game, what is the level of the court and what is the level of the law that the court is interpreting? That will determine the authority level within our hierarchy or our poker game of law. And I know that gets kind of confusing. I just want you to remember, U.S. Supreme Court interpreting the U.S. Constitution is the same as the Constitution itself. It's applicable everywhere, on down the line. All right. Executive orders are kind of the same way. Executive orders are not legislating law, but it's the president or a governor or a mayor or whatever issuing an order on how a law is to be enforced or not enforced or what means or methods to be used. So again, it may be an executive order on an administrative rule. So that executive order, can't contradict a statute or the Constitution because it's applying an administrative rule. So that's why I don't have those marked in green. That's why the 4 I really want you to know federally in terms of order of authority are these 4. Constitution, treaty, federal statutory law, the Code of Federal Regulations, and finally administrative rules. Okay, so last week, earlier this week, but last class, we talked about administrative rules. I forgot to bring my handy-dandy little book here. I just want to show this to you, because remember when I talked about the funnel theory? Big to small. The more we get down, the more detailed the law will become. So I brought with me today administrative rules, so you can kind of see what they look like. So again, I used to do a lot of trucking law. I still do some. But these are the federal safety regulations for commercial truck drivers. This is like 20 years old, right? They've changed a little bit, but not a lot. So this is a federal administrative rule. So this is part of the Code of Federal Regulation. And I just want to show you what I mean when I say detail. 'Cause, 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 'cause So like right here. If I'm putting together a fuel fitting, it has to match the 1971 Society of Automotive Engineers, the SAE standard, with a flare or a standard taper. I mean, that's pretty detailed, right? Or here's another one. The treads on a tire must have at least 2/32 of an inch of tread, or the tire is considered to be bald and unusable. That's pretty detailed, right? Or if you're going to be hauling rolls of steel coil, this is how you have to load them. You have seen that going down the highway. Or you can do it this way as an alternative way. So if you don't follow these regulations, if you're a truck driver, you're subject to potentially a citation. They do that at truck stops, or not truck stops, weigh stations. Or if a trooper pulls you over, or a sheriff, or a police officer, they could check that. And you get a fine, and it could be thousands and thousands and thousands of dollars. So that's what I mean by administrative rules. All right, let's move on a little bit down the line here. Okay, so I haven't talked a lot about state law yet, but again, under state law, sources of law, the highest level law at the state will be the state constitution. In Oregon, we looked at that already, the Oregon State Constitution. And we have statutory law, which are the laws written by the state legislature. We have administrative rules, which are written by in Oregon, the Oregon administrative rules written by agencies in Oregon, like Department of Education or Department of Fish and Wildlife, or other type of agencies we have here in Oregon. And there are dozens and dozens of them. And then we also have lower level decision, or lower level law. So we have city law, right? City code and ordinance. So here in Monmouth, for example, the city of Monmouth, we have a city council, and they can pass what's called Monmouth City Code. And these are laws that apply within the geographical boundaries of Monmouth. So they're going to deal with things like traffic law within Monmouth, noise ordinance, so if you're having a party and it gets too loud, the police show up and give you a nuisance violation. Or it could be zoning law, what you can do with your property. Can you build a house or an office building? That's all within Monmouth City Code, which is a form of legislative law. They call it an ordinance that is passed that creates code. And that's done by the legislative body of the city of Monmouth, which is the city council. Okay? We also have county code. So we're in Polk County. We have various counties throughout the state, Marion County, Washington, Multnomah, etc. And so the counties also have the ability to legislate through the county council, county commissioners, excuse me, and pass county code. So that'll be things like zoning, animals at large, like if your dog's running loose, or your cattle are running loose or whatever. Those kind of laws that apply outside of a city within the county. Now, city law and county law cannot conflict with higher level state law, and of course not with federal law. We already know that. So, but I just want you to be aware of that. So when I say state law as a whole, I am referring to the law written by the state legislature, but also cities and counties. I'm kind of lumping it all together. But I just want you to know in the real world we have these smaller jurisdictions. We also have other types of jurisdictions like TriMet up in Portland. That's the TriMet Transportation District that does Washington County, Clackamas County, and Multnomah County. And they have, the buses and whatnot that run around. They have the ability to make their own law within those three counties. We also have water districts, we have sewer districts, we have all kinds of subunits that can also make rules. I'm not going to get into that all here. I just want you to remember this basic rule. Number one, federal law always wins. Number two, at the state law level, we also have these levels with the U.S. Constitution, or the state constitution being the highest. Okay, so down at the bottom, a couple more terms that I referred to. I'm not going to spend a lot of time on these. Primary sources of law versus secondary sources. So a primary source of law is a law that is issued by a governmental entity. So a constitution, a statute, an administrative rule, a court decision, executive order, whatever, okay? We call them primary sources because those are the actual origins of the law that can then later be studied by academics, judges, lawyers, etc. Secondary sources of law are more academic in nature. And what I mean by that is a secondary source of law would be something like, you ever heard of a law review? In law school they have, it's basically a magazine, a periodical, academic, where they will analyze, a group of students with a group of professors will write an article about a specific topic. So it might be, for example, what are the constitutional free speech rights of a student in a classroom? An analysis. And then they will analyze court cases and other decisions and put that into an article. The article may be 200 pages long. That's called a law review article. And so we as lawyers, we can go look at those law review articles that analyze maybe 100 different cases and pull out parts of it to use in our legal argument. We can cite that to a judge as authority. It's not primary because it's not the actual law itself, it's an academic analysis of the law. We also have encyclopedias of law, kind of like Wikipedia of law, right? Those are encyclopedias. We have treatises. I think I have that on there somewhere. A treatise, which is basically a book that deals with a very specific area of law. Like, for example, my library, I have a 2-volume set, which is about, I don't know, 1,000 pages each book. The law of commercial trucking. Everything you ever wanted to know about commercial trucking law. Like whose fault if the wheel falls off a semi going 65 miles an hour down the highway because the lug nuts broke. That's a common thing. Very, very dangerous. Semi-truck wheel's about that tall, weighs about 150, 200 pounds, going 65 miles an hour and hits your car, it'll cut a car in half. Very easily could kill somebody. A lot of lawsuits over those things. So how much you torque your bolts and that kind of thing. So that's a treatise. They have treatises on everything from the law of gold mining, the law of cruise ships, the law of space and celestial bodies, which is, starting to become more relevant now, and all that kind of stuff. So those are secondary. Now I'm not really going to test you so much on that. The idea being that primary is an official government source and a secondary is more academic in nature. All right, so let's move on, son. Let's go back to this idea of judge-made law. Let's go over to page 16, I believe it is. All right, so we're still talking about judge-made law here, all right? So we know, so here's what this page is talking about, the doctrine of jurisprudence. Jurisprudence. So I'm going to highlight, first of all, the first part of that, juris, because we're going to see juris more so in a little bit when we talk about jurisdiction. Juris is the body of law, or the theory, or just law itself. If you're a jury, group of people deciding a case, right, that comes from that word, juris. So juris means law as a whole. Prudence, prudent or prudence is basically how the theory of how you behave or how you apply something or how you do something. So the term jurisprudence is the study or the theory of law. So if you go to law school, you graduate successfully, you are conferred with a JD degree. That's what I have, a JD. You know what that stands for? Not Jack Daniels. No, that's what you guys are thinking. It's a Juris Doctorate degree. So I have a doctorate of jurisprudence. So a doctorate in the theory or study of law. That's what you get in law school, here in the United States at least. There are other degrees you can get as well, but that's the primary degree to be able to practice law. So you go to law school, you study the theory of law, all right? So this page, again, what we're talking about now is when judges make a decision in court. Let's see, how do I boil this down? How much flexibility, if you will, does a judge have in interpreting a law and going beyond the strict written rule within that role of interpretation? And what this teeters on, just so you understand what I'm talking about, how far can a judge go away from the written legislative law before the judge is creating new law? How much authority does a judge have? And this gets into different schools of thought, all right? So this is a bit like political science in a way, where you have different political theories, Marxism, communism, socialism, thisism, thatism, myism, yourism, whatever. Economics, same way. We have different theories of economics, different social theories. Same thing in law. We have different theories in law, kind of like left wing, right wing, up wing, down wing, whatever. All right? So same idea. So on the one hand, we're talking about, on one side, a judge has basically whatever discretion the court feels is necessary to reach a reasonable or proper outcome, a just outcome. On the other side of the equation is a judge has to follow the law that was written by the legislature, because that's separation of powers. To deviate from the written rule would be a violation of separation of powers, because that's essentially a judge legislating or creating new law. So that's kind of our paradigm, right? One end versus the opposite. So on one end, on one extreme, if you will, we have what's called legal positivism. And this is the idea that a judge, when deciding a case, has an obligation to follow the written law exactly as written. No deviation, no making it up. The written rule is the law, irregardless of whether the outcome may not be just and reasonable. And the reason being, one, you apply the law that the legislature wrote. If that law is not correct, it needs to be amended by the legislature, not by a judge, because that's legislating. So that's a form of separation of powers problem. And part two is, if a judge applies the law strictly in one case but not in another case, that violates equal protection, because now you're treating people differently with the same legal issue. So that's this one idea of legal positivism. So for you guys, I just want you to remember the word positive. A judge positively must follow the written rule, exactly, no deviation, even if it leads to a kind of an unjust result. And I'll give you an example in a minute. The other theory, kind of on the opposite end, is what's called the theory of natural law. And really our whole legal system is sort of based on the theory of natural law. Natural law is the idea that, number one, people are born with inherent rights. And the whole concept of a legal system is to create a system that leads to a just and equitable result. And therefore a judge has, with built-in authority, that if a law, for whatever reason, if applied strictly would lead to an unjust result, then a judge has discretion to either throw the law out or modify the law to fit what would amount to a just result. Okay? And this would change over time, of course. All right, so those are kind of the two ends of the stick. So let me give you an example of what I'm talking about, so you can kind of see. I got to find my. It's been a while since I've opened this folder, like a year. Oh no, where'd it go? All right. So these two theories. So let's say this is our law. Okay? We do have a law kind of like this, but I made this one up. So let's say we have ORS 811.999. So this is an Oregon statute, and let's say that the statute says all motor vehicles must have a muffler, or a emission control device, right? So a muffler basically has two purposes. What are they on a car? Number one, to do what? Cut down on noise and cut down on pollution, right? Cut down on emissions. So two basic functions. Cut down on noise, cut down on pollution. And nowadays we have catalytic converters and all that too. All right, so that's the law. So let's say I go out and buy a new car, Herbie. We'll call him Zebra. There's my new car. Isn't that cool? 100% electric. It's a Zap car. One of the first electric cars. It's basically a three-wheeled golf cart. So I go buy my little Zap car, which I plug in to charge the battery at night. I'm driving around Monmouth, and I get pulled over. Police officer walks up. Hey, Hasbrook, how you doing? I haven't seen you for a while. We used to coach softball together back in the day, 20 years ago. And so he asked me, where is your muffler? I'm like, well, it's electric. It doesn't have a muffler. It doesn't need one. All right, well, the law says you have to have a muffler. It's got a motor, doesn't it? Well, yeah, it's electric. All motor vehicles, not some, all motor vehicles must have a muffler. And my little electric car here does not have a muffler. The law hasn't been updated to reflect new technology by the legislature. So, I get a ticket from the police officer for $350 for violation of ORS 811.999 for not having a muffler on my electric car. You're like, this is absurd, right? So now I'm going to go to court. So when I go to court, I'm going to be in front of a judge, and that's where this page comes in again, real world kind of situation. So if a judge is a legal positivist, the viewpoint of the judge is, I have to follow the law exactly as it's written. And in that case, what's going to happen to me? The judge is going to say, okay, Hasbrook, well, here's the law. Legislature wrote the law. Your car does not have a muffler. It does have a motor. It is a motor vehicle, albeit an electric motor, not an internal combustion motor. But nevertheless, the law doesn't make any differentiation. Your beef, Hasbrook, is not with me as the judge or the police officer. You need to go to the legislature and have them fix the law, to update it. I agree with you. However, I've got to follow the law as the judge. I've got to treat people equally. Separation of powers. I can't be changing the law. And so the judge would find me guilty. Would have to. That's legal positivism. Now you'd say, well, that's not a just result. Now the judge may say, okay, well, I'm only going to give you a 1 penny fine, and you can pay it with a Coke bottle or something. A 10-cent fine, pay it with a Diet Coke bottle. Whatever. But so the judge is going to say, clearly I agree the law needs to be changed, but I can't change it. Only the legislature can do that. Now I'm not happy about that, but in reality that's kind of correct, strictly speaking. But that's not really justice. That's not really the correct outcome. So what's the opposite? Natural law. This is the idea that a judge has the authority to deviate from, to interpret the law in such a way as to lead to a just outcome. So under that type of theory, let's say I have a judge now that is more of a natural law type of judge in their viewpoint. I'm going to argue to the judge, what is the purpose of the muffler law? The purpose is to cut down on emission, to cut down on noise. An electric vehicle, even though it does not have a muffler, does that based on its own design, implicitly with how it's built. It's quiet, and it does not produce any emissions like a gas or diesel or propane engine would. So therefore, this law, Judge, Your Honor, I'm going to ask you in your role as a judicial officer to interpret that this law was never intended to apply to a purely electric vehicle. And the just outcome to promote the policy of the law would be to find me not guilty because my vehicle is purely electric. And so the judge would say, Hasbrook, I agree with you. It's my interpretation that the correct outcome here to actually support the purpose of the law is to find that it does not apply to a purely electric vehicle. And the judge might add a little footnote, I implore the legislature to update this law. And that does sometimes happen. So you see the differences? Same law, same facts, different outcomes. So these are kind of the two theories of jurisprudence, sort of the polar extremes, if you will. Real world, this is part of what we do as lawyers. When we're going to court, we have to, I mean, if you're in front of a judge all the time, you know how they decide things. But, you know, if we have like in Multnomah County where they may have 100 judges, and you get assigned randomly to a particular judge, one of the things you look into is, you know, how does a judge decide this type of case? You'll read previous decisions from that judge, talk to other lawyers, that kind of thing. So that way you can craft your argument to the judge, you know, once you kind of know what their theory is. Now, real world, it's not that cut and dry by any means. So we have some of these other ones, which I don't really get into too much. I want you to know these two. But just so you know, the historical school of jurisprudence is really that the law should follow the historical norms and not change. The other one is sociological school of jurisprudence. This is the idea that law should evolve or change over the years to reflect current society. And that has its advantages and disadvantages as well. And then there's what we call legal realism. And this is basically the idea that in the real world, a judge is not really one way or the other. Just like all of us, you know, you can't just put us into a category all the time. It will depend on the case. And so in the real world, most of the time, a court or a judge, they're going to start off as a legal positivist and try to apply the law as it's written. But clearly, if it's going to lead to just an outlandish result, then the judge is going to say, well, more of a natural law kind of idea. And that's legal realism. And this is very true real world. I mean, there are judges that, I remember one particular judge that did not believe that prostitution should be a crime, as long as it was, you know, adults. And therefore, the court would never find a person guilty of prostitution, even if they admitted to it, you had it on videotape, no matter what. That same judge, however, if you were in court in front of them for a driving under the influence case, 30 days mandatory jail, even first offense. And so that was kind of their personal viewpoint on how they, you know, decided cases. And so if you knew that, you can craft your arguments that way. Now, I'm not going to, you know, I just want you to know kind of the difference here. This makes a great essay question. What are the pros and cons of each theory? I won't do that to you, I promise. That's a different class. All right, so that pretty much wraps up for this subject matter. So next week we're going to start talking about the court systems, and we're going to get into what's called jurisdiction. And with that, it's a wrap. We will see you next week, and have a good weekend, everybody.